Good,
sovereign.
good afternoon, everyone. I am Akshat Khandelwal and I am a final year law student and founder at Law Pulse. I welcome you all to today's session on contracts, challenges and force majeure clause in era of COVID-19. To further enlighten us upon this topic, we have with us a company secretary turned lawyer and managing director at Amicus Legal Advocates and Consultants, a reputed corporate law firm based in Jaipur. He is a regular face before Economic Offences Court and Commercial Courts and High Court in all commercial matters and civil matters. With over 10 years of vast experience in the field, he has various judgments to his credit while appearing as arguing counsel at Supreme Court of India. So, ladies and gentlemen, we have with us Mr. Susshil Daga. Welcome, sir. We are glad to have you. Sir, over to you.
Thank you so much, Akshat. Thank you. Sincere thanks to the entire team of Law Pulse. You're doing a great job. Yesterday, we had a very good session on how to argue writs. I think the learning in the COVID time should always be there, because there is a situation where we all are feeling that probably now COVID is getting better of our mental fatigue. So in such a situation, it's always better that we keep doing something. Sorry, the video got mute. So everyone is looking forward to this session, and majorly there are certain professionals I can see who are joining and law students. As far as professionals are concerned, the businessmen are concerned, they are looking at force majeure as if it's a God clause, and it would be the saving or the silver lining in the entire COVID situation. The dark clouds of COVID would have the silver lining of force majeure, is how we are seeing it. I must first put the rules on the table, that what are we going to discuss in this lecture. This is going to be a very crisp lecture of around 45-50 minutes. I presume the time that has been allotted is around an hour, kind of. But I'll try to close it within 50 days so that we can take Q&A also. So when we are discussing force majeure, I think we are not going to discuss something which is consensus. If two parties are coming together and deciding that we might do things in a particular manner which is not as per the contract terms, also not our domain, not the legal point, we are not going to discuss. We are also not going to discuss on what should be the law, what ought to be the law. We would probably, and limit our discussion today, is what is the law today? What is force majeure? And if it is there in the contract, what would happen? If it is not there in contract, what would happen? What are the statutory provisions that would help us? 400 years of English law and 70 years of Indian jurisprudence. What are the major judgments? 5 major judgments we'll try to touch today, which will help us understand frustration of contract, force majeure of the contract, and we will very light at the end, very briefly we will touch upon issues relating to wages and labors also. While we'll take Q&A answers, I think the most important question and answers that would come relating to rent issues of various companies and whether it would constitute force majeure or not. I think the way we discuss or we take through this presentation, those questions itself will be answered. If any left, we would take it thereafter. So force majeure, not an Indian term, a Latin term. So force majeure is generally right now in common sense, in common parlance, being dealt as at any place if we are unable to perform, or probably there's a difficulty in performing, or there's an onerousness in performing, or probably there's a toughness in performing. there's difficulty in performing, all of that would constitute as force majeure. We cannot go out, COVID situation, so how do we do any contract? Force majeure. No, not the right approach, not the legal approach. Let's start it from the very basic. Force majeure, as has been dealt in various judgments that we'll take forward, does not mean that anything which is difficult to perform. Force majeure would, if at all, be statutory dealt. It has been dealt in two major sections. If people are jotting it down, I think these are two major sections that we need to know. One comes from chapter 3 of Indian Contract Act, which is section 32. Chapter 3 talks of, the heading of the chapter 3 is contingent contracts. And contingent, as we always know, contingent means on happening and non-happening of an event is a contingent event. And section 32 is the most relied upon section whenever such issues of force majeure has reached the higher courts. Section 32 has been resolved. We will discuss as latest judgment as of 22nd April 2020. Yes, I'm correct in saying probably very close to lockdown. A larger bench judgment passed by larger bench judgment of this Honorable Apex Court, Supreme Court of India, National Agriculture versus Alimenta SA, where the larger bench of Honorable Supreme Court of India decided a very crisp issue, that if there is a force majeure clause, which section would apply? Whether it should be section 32 or whether it should be section 56. So all of that will be dealt, but let's start by reading. I think these are very small, very crisply drafted act. James Stephen has put a lot of effort, and we see these Contract Act coming with a lot of illustrations also. Section 32 of Contract Act also comes with 3 illustrations. Section 32 reads as, enforcement of contracts contingent on an event happening. Contingent contracts to do or not to do anything, if an uncertain future event happens, cannot be enforced by law unless and until that event has happened. If the event become impossible, such contract become void. And here is where everyone right now in this world wishes to fall. At least in India, we wish to fall in section 32. We say that the event becomes impossible, such contract becomes void. Now, this, what would this impossible mean, has been taken care in various judgments, and that we will see. Illustrations are very important. These illustrations have been always guiding force in writing any of these judgments. And the first illustration is very important. It says, A makes a contract with B to buy B's horse if A survives. A survives C. This contract cannot be enforced by law until unless C dies in A's lifetime. So such contracts which are not enforceable or which are contingent in nature are being part of section 32. When we see section 56, section 56 is more to do with impossibility to perform. And it comes in section 56. The heading of the section itself says, agreement to do impossible act. Like if I am to say that if I do black magic today, Corona would disappear from the world tomorrow. And if I try to enter into such type of a contract, section 56. So that would mean agreement to do impossible contracts. And the illustrations are such. First illustration to section 56 says, A agrees with B to discover treasure by magic. The agreement is void. A and B contract to marry each other. Before the fixed time of marriage, A goes mad. The contract becomes void. Suppose Law Pulse did a contract with me to deliver this lecture today, and I have a serious bad throat and I cannot even speak. So this contract would fall within the definition of impossibility. It would come within section 56 because the element is such. Now, the important aspect relating to section 56 is the supervening effect. there should be a supervening effect whenever you contract and you claim that you will fall within section 56. That is impossibility to perform, because there may be possibility, there may be impossibility. Subsequent superveningness makes it void. If subsequent superveningness is such that it is very difficult to perform, it would fall within the definition of section 56. And this is what Honorable Apex Court has also held in the latest judgment, that once you have a clause relating to force majeure, see section 32. See section 32, that it is a contingent contract, and go thereafter. Now, how do we understand force majeure clause? Let us take a very crisp example. IPL was supposed to happen in India, did not happen. It has been, as of now, been postponed. Wimbledon was supposed to happen, did not happen. But you know what? Wimbledon had this clause. The insurance company, the insurance contract had this clause that if at all it is affected by pandemic, it would be taken care in insurance. Wimbledon is being compensated. However, as a legal person and as of more than a decade that I had spent in this stream, there are lesser contracts we have seen where force majeure clause also covers a situation where it is pandemic, or situation where pandemic leads to unenforceability or making it difficult to discharge the performance in the contract. And that is why most of the situation would come where force majeure clause, despite having a force majeure clause not being a very specific, we have to rely upon section 32 and 56. So I've chosen 5 judgments basically to go ahead and discuss force majeure or frustration. Now, before we discuss those 5 judgments, we'll deal with, and I'll let the citations also come so that people can jot it down. But before force majeure starts, let's understand that there is a situation today and we allege that it's a frustration of a contract, I cannot perform at all. What are the basic principles on which we will try to rely on? The first principle we may very well argue is that probably we both the parties had, it was such a basic nature of a clause that we probably did not feel it proper to mention it in the contract. Like A says to B that I would supply a certain goods to a different state, but he said that that is only possible if intrastate transportation is allowed. If that's not allowed, probably I would not be able to deliver the goods. So it's the basic thing, and there's no point even writing it. It's an implied contract to it. So the first argument that can be developed probably is that it might be an implied thing, and not writing of such clause will not vitiate the purpose of having something implied force majeure kind of a thing. Second, and the most second thing is, when we approach to the court, we say that you may see the situation that it is actually impossible to perform, and the court rewrites the contract or contractual terms. Or by rewrite, I mean court tries to interpret it in a manner that it leads to rewriting of a contract. Third possibility is that when you approach to the court and you say that in all possibility and in all reasonableness, it is actually not in a situation that the contract can be performed. That is called principle of reasonableness. If the principle of reasonableness is claimed, then we have to move to a different situation. In my understanding, if these 3 situations are to be argued, if I have to put my weight behind any of the thing and present the matter in the court, I think the third principle is something where probably we can get something for the client. Claiming implied consent or implied contract is something probably which is very difficult for anyone to explain. So before we start or dealing with how have courts interpreted a frustration of contract or force majeure of contract in various judgments, let's first see what would lead to frustration of force majeure of any clause. Let's take a small example. Supposedly, both the parties presumed that the crude would rise. The rates of crude would rise and enter into a contract, and rates of crude did not rise. whether either of the parties can claim that whether it is a force majeure situation or not. The answer is no, because happening or not happening of an event would not allow you or entail you to absolve from your contractual liabilities. The basic or the thrust of this principle of force majeure, the foundation of this principle of force majeure lies on not on difficulty, not on onerousness, not on toughness. It lies on that if at all both parties now agree to enter into a contract, it would actually lead to rewriting of the contract completely. That would form the basis of force majeure. It would not merely one citing commercial difficulty to perform a contract would not lead to it. At this juncture, let's start with one of our, we'll start with our judgments. And the first judgment that we start with is judgment of Bangur, Satyabrata Ghosh versus Mugni Ram Bangur, 1954, page number 44. This has been authored by one of the most illustrious judges India has seen, Justice B.K. Mukherjee. And he probably, there's a story attached to him that he died the next day. He resigned today and he died the next day. And that's, and his judgment speaks, I think judgment speaks for how illustrious a judge is. And the moment I read this, or we have read judgments of Justice B.K. Mukherjee, you still have those goosebumps of the clarity of law the judges had. Satyabrata Ghosh versus Mugni Ram Bangur, AIR 1954, page 44. I'm repeating it so that people who are jotting it down can do it. This judgment deals with a situation probably more worse. I'm stressing on more worse than what COVID is presently. It dealt with a situation of world war. It dealt with a situation where there was war in place, and this is prior to independence, where Englishmen declared that there is a requisition and we need a certain part of land to be dealt with, and we need a certain part of land, and they acquired it during for the law for the purpose. So basically, for that land, he had already entered into a development agreement or a contract where he had taken certain money from the person to which flats and other aspects were to be supplied. So he went on, the builder went on and said to the seller that I give you two options. Since I don't have the piece of land now with me, but I may digest from this, I'll take a step back and explain that this land was not taken permanently by the Englishmen. It said that we would take it only for the war times, and once that is over, it would be returned back to the builder. So he approached to the seller saying that please understand that it's a war situation right now. We don't know how long this will go on. And so therefore, I give you two options. Either you can take your money back, or probably you can take the land on as on wherein basis, subject to the requisition order of British India. And that is how we can go about. If I have to answer this without reading the judgment or without reading the force majeure law for the first time, my answer would be no, he is reasonable. The man is very reasonable, because he says either take your money back or either take the land on as on where on basis. You'll of course get it back once the war is completed, because that's the requisition about. The court did not think so, because the seller approached the court. He said that there's no frustration of contract, there's no force majeure situation. And the court said, yes, he's correct, because it's a temporary difficulty. It's a temporary difficulty as of now, and he would get his land back. Time though being essence of the contract, but it does not make or absolve him that if time is essence of contract, section 55 would follow if he could not perform it within time. And if it, therefore, in this warlike situation also, the Honorable Apex Court relied on various English laws and said that no, it would not entail the builder from absolving from the contractual obligation on the pretext of force majeure, on the pretext of frustration of contract. And that is where now I come to my second citing of my second judgment. Alopi Prasad versus Union of India. Alopi, ALOPI, Alopi Prasad versus Union of India. And when we read this judgment, the citation is AIR 1960, Supreme Court, page 588. AIR 1960, Supreme Court, page 588. Now, this is very interesting judgment. And why I say very interesting? Again, war. Much difficult than COVID. COVID, you have option of sitting at home and not being affected by it. Whatever is being affected is economy. Economy can always grow. You lose on other things, which is something like life, I think not recoverable. War comes with that kind of a situation. Alopi Prasad was a supplier of ghee. Ghee khate hain? He was supplier of ghee in military. And the war broke. It is relating to 1937. And that time, again, this was a war-like situation, though it was decided in 58 by Supreme Court. And he said that I was supplying ghee and I was in regular touch with Indian Army that time. And I kept on saying that the rates have become such that the contractual rates are now not feasible and I cannot supply it further. The judgment talks of his oral discussion with the military and his alleged part that the rates would be compensated thereafter. So he may continue supplying something of this sort. When matter went to the court, court said no, nothing doing. And this is the point where I would want you to, I'll take you through reading this judgment for a moment. Akshat, can I have a share option? I wish to make people read this para 21.
Yes, sure.
Yes, I got this share screen option. And it's a classic judgment that has been written. And para 21, I think something which will go to the root. Para 21, it says section 56 of Indian Contract Act, a contract to do an act which after the contract is made becomes impossible. So he said that now the rates are such that it has become impossible, or by a reason of some event which the promiser could not prevent unlawful, becomes void when the act becomes impossible or unlawful. And the next paragraph is so very important. The one I'm putting it as in this color. Performance of a contract had not become impossible or unlawful. The contract was in fact performed by agents and they have received remuneration expressly stipulated to be paid therein. The Indian contract does not enable a party to contract to ignore the express covenant thereof and to claim payment of consideration for performance of contract at a rates different from the stipulated rates on some vague plea of equity. So people, that is how I have started my judgment, my presentation, that I might be there with you when you talk of equity, but that is not the topic on which I have been asked to speak by the organizers. The topic today right now is that we are discussing on force majeure and the legal principles to it. So the legal principle did not allow him, and he was not allowed to seek any relief under the garb of or in the light of force majeure clause. And here is when I enter into another judgment, and the judgment is Nihati Jute Mills versus Khayali Ram Jagannath. So the previous judgment was again by Justice J.C. Shah. Justice J.C. Shah also features in this judgment This is AIR 1968 Supreme Court, page 522. This is very interesting. This judgment again is very, very interesting because this talks of, again, war situation or a kind of a war situation. In the judgment, what happens is the Indian government used to provide licenses if you wish to purchase something from Pakistan. Supposedly this matter relates to jute. So they said there were circulars in place that if you wish to purchase jute from Pakistan, you have to satisfy that you first try to exhaust Indian things and then move to Pakistan. And the circular probably talked of 4 times you purchase from India and then once you can go for Pakistan. So they entered into a contract saying that Indian party would be responsible for getting this license. And if this license is not received by October, this would be the payment in December. And if it is not received in December, and this would be in thereafter. Hello. All well? I'll request everyone is coming here as professionals. Please put your mic off on yourself. Let the host also be with us while we are doing this lecture. So while the license was applied, the license got rejected. Since the license got rejected, the party claimed that it's frustration of contract. Since license is not there, I cannot perform the contract, and I have done all my reasonable effort to obtain the license, but the license have not been given. So the basic thrust itself gets difficult. So kindly absolve me from the particular situation, and he pleaded frustration. The court relied on catena of judgments. Once we go through these are illustrious judgments where a lot of English law has been quoted. And the court said in Niyati Jute Mills, it's a larger bench judgment. It's a judgment of three judges by Honorable Apex Court. And they said that no, it's you not getting a license is a difficulty on your part because licenses were provided. Maybe out of 5 cases, license was provided for 1 case, but it was provided. Hence, it cannot be said that it was impossible to perform. Yes, it was difficult to perform, but with open eyes, you have entered into a contract where you know that such a situation was there. And in this case, exactly, probably parties knew it was difficult for them to procure the license. So once you enter into it, if there was a situation, India government would have rejected that all licenses, no licenses would be given, or no jute from Pakistan would come, or no importer would be granted that license. Fair enough. You might have come into a case. You might have had a case before the court. But right now, the situation is such that licenses were provided, but sparingly. It was provided in such a manner that it was not provided to everyone. So again, court applied the tough hardship yardstick while deciding this judgment. So these 3 judgments, I think if we go on and search for judgments on force majeure or go on and search for judgments on frustration of contract, more than hundreds of judgments we would get. But I could find my little interest in these 3 judgments specifically because these talks of a situation which are much worse than what present day today we are facing. And the present day is COVID situation where we at least know that if following things are done correct, or we can foresee that we might get into normal situation. The last judgment, I think the modern day great, Honorable Mr. Justice Rohinton Fali Nariman had authored this along with Justice Pinaki Chand Ghosh, retired Judge, Supreme Court now. The judgment is of Energy Watchdog. I think anyone who is dealing with force majeure today or talking about force majeure, one important judgment that everyone has to read through is Energy Watchdog. And Energy Watchdog, it's an interesting judgment. It's a judgment. If you see the lawyers who have appeared, I would like to show lawyers who have appeared. That would interest everyone to go back and read this judgment also. sometimes we see the best of the legal brains who are appearing. That also excites us. So look at who is appearing. I think we should look at who is not appearing. Everyone from top legal luminaries we know about, we talk of, everyone is there here. Everyone is here. Commercial law, the best of the legal eagles of this country were doing it. And then we see one of the finest judges Indian apex court has authored this. Now while we discuss this judgment, what happened in this judgment was the Adani group were supposed to provide electricity, and for not providing electricity, they said that we were supposed to procure coal from Indonesia. And Indonesian law underwent a change. The policy changed, the law in Indonesia changed, and changed to the extent where the prices had shot up in such a manner that it led to a situation that procuring coal from Indonesia thereafter and thereafter supplying electricity is actually a situation of frustration, because commercially it's impossible to do it, commercially it's not viable at all to do it, and change in Indonesian law should be treated as a difficulty or impossibility to perform, and they should be excused from performing their obligations. All of this was said, and argued at length. This was argued for a good number of days. And then the Supreme Court curled out and negated all these points, and the judgment said that the contract talks of supplying of electricity. The contract does not talk of where do you procure coal from. So if you're procuring it from Indonesia, it's your headache, it's not written here. So change in Indonesian law is also not a subject matter of the contract, that any change in Indonesian law will also affect or vitiate the performance of the contract in this particular contract. However, if there was change of Indian law, that would have helped them, but that's not the present case. There's a very interesting judgment of Sakir Gura that was cited. It's an English judgment. In this judgment, a very interesting thing happened. I'll take you through the paragraph, and it will be very interesting read for everyone. Here you are, para 37, and this talks of frustration, and he applied for frustration, saying that I was supposed to supply the goods through Suez Canal, and it was held that contract of sale of groundnuts was related to it, and since there was a war-like situation, so I could not have gone through Suez Canal, and therefore I must be allowed to plead frustration of contract. And the court said that it is a difficulty to perform, and we accept it. However, there is another route that is available, that the ship would have to go through Cape of Good Hope. So you had an option of going through Cape of Good Hope instead of Suez Canal. So there is a difficulty to perform, but it is not impossibility to perform. So the difficulty to perform does not invite you to claim that it would lead to frustration of contract and absolving you from contractual obligation. And that is how this was thereafter dealt. It was dealt that frustration of a contract is not the commercial difficulty. And since the third principle that was curled out was that there is an existence of an alternative. If there is an existence of an alternative to perform, then again, it would be a situation where things can be done, once things can be done in any manner whatsoever, it is supposed to be out of the purview of frustration or force majeure. Mere price or commercial difficulty would not entail claiming that there is a frustration of contract. Now, here is a situation that we are right now, and there is this judgment now of 22nd of February 2020, which, to be honest, I had opportunity of laying hand at 1:30 p.m. while I was going through certain other things. So I'll not rely too much on it, but yes, again, it's on force majeure, good 70-page judgment, authored by Honorable Mr. Justice Arun Mishra, Judge, Supreme Court of India. We might see that judgment must also have certain things to go through. But what is clear today is, if we see a situation which is difficult to perform, if we see a situation where we claim that workers are not allowed to move interstate, these are all temporary. COVID is not a permanent situation, and it will be very difficult for anyone to cite this as a reason and at least win in the court. Now, thereafter, if we see the judgments, let's see the international perspective also. And one judgment from Hong Kong got my special attention. This is of relates to perfectly, and this was decided in year 2003. And you know what? This relates to an epidemic, SARS, SARS. Hong Kong court also applies English law. And so the entire judgment is filled with two major English judgments. One is of United Courier versus Panalpina Carriers versus, second is Crickwood. And I'll deal with Hong Kong case first. Hong Kong case, the landlord, I think everyone who is coming here for landlord and tenant and understanding what would happen thereafter, this judgment will fit it like a glove. If we see this judgment, what happened? SARS broke out. The landlord tenant had a contract. Contract was for 2 years. Contract was for a period of 2 lock-in years. The particular block where the tenant was living, there certain members were diagnosed with SARS. So the tenant shifted his premises. And thereafter, when he came back, he said that I'm not going to live here. Whatever advance or etc. other things you are having, you may keep it with yourself. And I am going to leave, and no further rent would be paid. The landlord filed a suit, and while deciding this, they referred to 2 judgments. One judgment relates to a very interesting case from United Kingdom House of Lords, National Couriers versus Panalpina Northern Limited. And in this judgment, what happened? There was again a landlord, there was again a lease for 10 years. And the warehouse for which the lease was there, the street leading to a warehouse was closed for good 1.5 years by their local municipal authorities. That street was closed for a good 1.5-2 years. So he claimed frustration that this has been closed for a time period which now frustrates the contract. Court said, nothing doing, it does not frustrate the contract. Your lease is for 10 years and this is just a temporary aberration. This is a temporary difficulty. So no force majeure to apply. So the judgment of Hong Kong relies upon the judgment of United Kingdom House of Lords National Couriers versus Panalpina. And we too keep citing the judgments of English law. So this will be handy to understand. Similar was the case. There was another judgment cite here, was of Cricklewood Property Investment Trust. This was of 1945, and a very similar case happened in that, and they said that no frustration of contract. So once we see these judgments and understand, I think we are in a situation that we have to get over the fact that everything where we are unable to perform, and we would be able to take shelter of this terrific clause called force majeure, FM would help us. I think we are in a we are in a space of botheration. However, when I was going through two of the notification, one by Government of India, Ministry of Home Affairs of 29th March 2020, of 19th February 2020, Ministry of Finance, Department of Expenditure Procurement Policy Division. They said that attention was invited to para 9.77, and I'll share it with you because this is very important. Share screen, I'll do it with you. Can everyone see this? This is Ministry of Finance office memorandum, and the subject is force majeure clause. This is of 19 February 2020, and they have put a force majeure clause explaining into it, and they said that a doubt has arisen if disruption of supply chain due to spread of coronavirus in China or other country will be covered in force majeure clause or not. Force majeure clause. In this regard, it is clarified that it should be considered as a case of natural calamity, and force majeure clause may be invoked wherever considered appropriate following the due procedure as above. I think this will become very important when we will deal with contractual matters relating to government. Citing of this office memorandum will be very important. Similarly, Ministry of New and Renewable Energy had followed this office memorandum of Ministry of Finance, and also has issued office memorandum citing all of this. So this would again become very important in dealing that probably the government is more inclined in allowing its contractor try to invoke force majeure clause and proceed likewise. Now, I think I've took exact 45 minutes now to conclude it. We would start with certain Q&A, and thereafter we can have a little discussion about wages, and let's see how the organizers see thereafter.
If anyone has any questions, they can put the question in the chat box.
One major question that generally that has come to me, and one of my friends have asked, Mr. Dinesh Sharma, company secretary, has asked me to address, that this present situation, everyone is in difficulty in paying their rent, and there's a serious difficulty in addressing this situation of paying rent. So paying rent, I think, is a very difficult aspect, and there can be sympathies to it, but I think one should try and get consensus into it in getting waiver of rent. If the legality has to be seen, then the agreement has to be read, and most of the rent agreements, I think, would not have this force majeure clause, and even if it has, it does not have this pandemic kind of a situation in the force majeure clause. So it will be very difficult to get away from paying the rent right now. But I think a majority of the people will get consensus. We see a lot of otherwise also we see a lot of banks sending notices. ICICI bank has sent plethora of notices now. They have sent around, they are dealing probably in 1200 crore rupees of rent is what is at stake. And they've sent notices that probably this is a force majeure situation. I don't know. There must be people who would allow it on consensus basis. But if not allowed and they have to go to the court, I don't think the law is such today that it would stand in their favor. The law does not have one quotient, and that is called sympathy. It has to only go by its legal principles and move on. And that is why we can apply and read these judgments. If sympathy gets into it, it will be very difficult. So as far as rent is concerned, this issue has to be seen. Yes, Akshat.
So, sir, we have questions here. So, Mr. JP Rawat has asked, so you want to say that in the case of COVID, force majeure will not apply?
No, that's not my answer. He's a senior company secretary as of what I know, JP Rawat sir. COVID situation does not, if at all the agreement covers the situation. Force majeure, if it covers the situation, that it would lead to force majeure. If the agreement covers it, one, it would apply. Second, if we are able to prove that the substratum of the agreement at all gets vanished and it cannot be performed at all unless and up till the it upsets the foundation of bargain between the parties, it would again lead to a situation of force majeure that has to be impressed upon the court. I said on the principle of reasonableness, if these matters go to the court, we have to show that the parties are in such a situation that the foundation has altogether been foundation no more exists, and further, more than foundation, if at all the contract is to be written today, it would not be the same of what it was written previously. And this is not the principle that has been there in law books, but these are the kind of principles that have curled out from these judgments.
So, sir, the next question is asked by Mr. Chitransh Mathur. So, he's asking that if during COVID-19, someone enters into a contract, so can you please explain this with an example that we people are coming into the business of hand sanitizer, manufacturers like things. Subsequently, they enter into contract with raw material suppliers, and now the raw material suppliers sell the materials to third party on higher prices and takes plea of force majeure as he does not perform his part of the contract with the first manufacturer.
Chitransh Mathur, your lawyer, don't go into manufacturing of anything, but if I have to little guide you in this, let's first see that force majeure is not the defense to not perform a contract. I think force majeure is being seen in a general parlance that it is now a shield that if we use it, we'll be free from our obligations envisaged under the contract. More so more your situation, with open eyes in this COVID situation, you enter into a contract not envisaging anything relating to COVID and not performance of it. I think the plea of force majeure would not survive.
So the next question is from Samriddhi. So she is asking that what if someone files for damages due to delay in the fulfillment if obligations as laid down under the contract? Would that be allowed?
Akshat, I could not hear. Sorry. Can you repeat?
So, sir, she's saying that from what she understands here is that claiming frustration of contract is very difficult. But what if someone files for damages due to delay in fulfillment if obligations as laid down under the contract? Would that be allowed?
Look, for damages, there are other number of judgments. For damages, Section 55 of the Contract Act, Section 73 of the Contract Act are also to be seen. And we, in arbitration, if you see, there are catenary of judgments talking of how damages can be claimed, if at all not even mentioned in agreement. I think McDonald International was one of those judgments where it said that though it's not mentioned in the contract how damages has to be calculated, it can be done. So it is not a case where someone cannot claim damages, but solely on the basis of claiming temporary difficulty damages are claimed. I think it will be the first line that of her query is very correct. It is difficult. Okay, it is very difficult.
So, sir, here Ms. Khushbu is asking the another question is that if the word epidemic or pandemic is not mentioned in the force majeure clause, but the word governmental restrictions, act of God is mentioned, can force majeure clause be invoked? And what is the terminology of rent suspension? Is it similar to rent waiver?
So the question is very interesting. It says that governmental restrictions. So governmental restrictions, whether these are temporary or whether the government restrictions are for throughout the contract and it cannot be performed at all. The point remaining, we have to see whether the restrictions, I had cited this judgment of English law, uh, United Career versus Panalpina. Out of 10 years of lease, 2 years could not be done. I think much worse situation than present situation today. So what court said that temporary is the word, difficulty is the word, commercial difficulty is the word, no force majeure.
Okay, sir. So CS Ramdev Singh is asking the another question. How does a party prove that it attempted to mitigate or avoid the force majeure event?
I think it would all depend on case to case basis. These are such principles where there cannot be a straitjacket formula that if 1, 2, 3, 4 is attempted, it would lead to getting satisfying that all has been done to invoke and get relief that force majeure event has happened. He's a senior company secretary from Mirage of, if what I know is the name is correct. Ramdevji would address this, that most of the contracts he might have seen in his life, I think relates to a situation where such an issue has not been addressed. So this is a temporary difficulty. Force majeure, if at all you mentioned in the contract that in pandemic situation or in epidemic situation, if a certain time period is lost, it would be construed as force majeure clause and following things would thereafter follow. That would happen. Or you try to satisfy the court that situation is such that there cannot be performance at all. It's now led to impossibility of performance. Difficulty of performance would not lead to it.
So the next question is from CS Dinesh Sharma. He's asking that force majeure is applicable in case of natural epidemic as COVID-19 is not a natural disasters like earthquake and other. As professionals, a big challenge is office rent and others. How we will deal with this?
I think I've taken up his question. I think already I've taken up his question that again, he has answered his question while drafting itself. Last he says it's a big challenge. So challenge is no shelter of force majeure. Bhavik says that can you read this question from Bhavik?
Yes, sir. Can we insert COVID-19 as pandemic disease in our force majeure clause for upcoming contracts like earthquake and war?
Someone coming from a very nice industry, cement industry, and he's looking forward now. He says that whatever is gone. Can we now do it now? Yes, one should always do it, Bhavik. We should definitely insert such clauses. I think, I don't know what led Wimbledon do it while it was doing its insurance 4 or 5 years back. But I think now at least our eyes are open. We should definitely put such clauses.
So there are no other questions.
I'm thankful. So, it's been privilege to address on this issue. This can go on. We had only hand-picked few sections, hand-picked few judgments. I think a detailed discussion on this can always happen. We have our set of limitation when we are doing it through the app. I must compliment the organizers, Law Pulse. They are young students, but they have chosen the topic very well. And thank you to everyone. I think during this pandemic situation, 2 to 3 is the time where everyone takes a nap. So if you have avoided it and heard, I'm so thankful to everyone.
So thank you so much for sparing out time from your busy schedule and for such an insightful
I think Yash Parikh has come up with a question. There's one more question I see.
Yes, sir.
If there
is a written in an agreement that written notice would required for termination, how to deal with it in given situation if we want to terminate the contract?
So if I'm not wrong, Mr. Parikh, company secretary from a very listed company, is trying to ask that contracts relating to employment, whether those can be terminated in the present situation. I think given, I'll take a minute or so to discuss it and then we can close. Akshat, can we?
Yes, sir. Yes, sir. Sure.
Look, there, as far as wages are concerned, there are a lot of advisories that have been given by Ministry of Home Affairs. Home Department, Union Ministry has given certain advisories. And the nature of advisories are they are not binding. Barring one of 29th March 2020, which places its reliance on Section 10(2)(I) of Disaster Management Act, where it says that you should provide wages. And I think barring this, there are 2 or 3 more advisories which says those are advisories does not have enforcement value. As far as this advisory of 29th March 2020, base its reliance on one of the sections of Disaster Management Act, and that is how it has its strength. So it provides for this. As far as any other matter is concerned, if we talk of employment matters and other matters, it would not be consciously correct or right on anyone's part to dismiss or do away with anyone's job. But that's the emotional content. The legal answer to it is, if there's a contract between an employee and employer, the process mentioned in the contract can always be followed by either of them, and thereafter the contract could go. We citing that generally if the jobs have to also been taken, we have known this industry, they will always ask you to put a resignation on personal basis, and that is how it is done. It's very rare that people fire someone. This is how it is being dealt. So as far as the contractual bases are concerned, Mr. Parekh, the contract and its terms are sacrosanct between both the parties. They both have signed it with open eyes. That is how they have to deal with it.
Thank you so much, sir.
Thank you so much.
The way you emphasized on the key judgments were commendable, and I think that it will be clear in all of us and the participants that what is the applicability of this clause in these times of COVID-19. Thank you so much, sir, and thank you everyone.
Everyone should read this judgment, this latest judgment of National Agriculture Corporation versus Alimenta SA. This is a larger bench judgment of 22nd of February 2020. I think we all will have some more aspects to learn. Thank you very much. Shall I sign off now?
Yes, sir. Thank you, sir. Thank you so much.
Thank you so much.